Welcome, everybody. This is Dr. Brian Capra from Billing Precision. Tonight on the phone we have Jeff Randolph. Jeff is the ANJC's General Counsel, and most notably, recently has won was the lead counsel on the case where the ANJC won against Horizon Blue Cross Blue Shield. And I won't get into the details of that. I'll let Jeff explain that. But what we're going to do tonight is we're going to discuss what the actual ruling was and what it is exactly that you should be doing as a chiropractor in New Jersey to make sure now that you get paid for those E&M codes and those modality codes going forward. And then we're also going to obviously add a little bit about, for our Billing Precision clients, how you actually do that within our system and how we've made that even easier for you to do with our system, our technology, and how we're partnering up with Jeff for him to actually appeal those claims for us. So, Jeff, thank you so much for taking the time out, and not that you haven't already done enough on this, but now you're actually helping everybody out and telling them what they should do next. So if you want to take over the slides and just kind of start off and show us what's going on here.
Okay, thanks a lot, Brian. I appreciate you having me here tonight. We're going to talk a little bit about the decision and exactly what brought us to where we're at and what the decision states, and then more importantly, what is the chiropractor to do now the decision's been rendered and Horizon appears not to be really complying with the decision and isn't paying the claims. So, I mean, first off, October 7th, 2009 is the date that the New Jersey Department of Bank and Insurance issued its ruling on the administrative hearing. And basically, this is an administrative action that was started by the ACA, and the ANJC joined it roughly in about 2006. We had a 4-day hearing before an administrative law judge, and who took a whole bunch of testimony, found some facts, gave a decision to the Department of Banking and Insurance. The Department of Banking and Insurance wasn't satisfied with the judge's decision and essentially looked at everything anew. And on October 7th, they issued their final determination of the matter. Now, this is what the Department of Banking and Insurance found. Now, there were 4 issues. The first issue is whether Horizon was violating, it's called the Unfair Claim and Settlement Act. That's what UCSA stands for in this slide. And DOBI was looking to see whether Horizon violated that act by bundling the evaluation and management services of chiropractors into the chiropractic manipulative treatment codes, which is CPTs 98940 to 942. And didn't review each claim separately for medical necessity. And DOBI actually found that they were violating that act by doing that. What Horizon had been doing since the chiropractic manipulation codes had been issued in 1997, they had basically been bundling those E&M codes into the CMT and just giving a blanket denial. Every time a chiropractor submitted an E&M code, they would deny it, saying not that we're not going to pay for it. They were saying that we're reimbursing you for both the CMT and the E&M by paying you once for the CMT. Now, the Department of Bank and Insurance found that that was improper. It was in violation of New Jersey law, and they told Horizon to cease and desist. Now, the second issue here in the bullet we have is DOBI also found that Horizon had violated that act for bundling physical therapy modalities and treatments into the CMT along the same lines. DOBI found that Horizon should be looking at each claim separately to determine whether they're reimbursable, as opposed to just giving a blanket denial based upon a reimbursement policy that says that those modalities are bundled into the CMT. And Horizon's theory was basically that modalities are really just kind of warming the patient up or assisting with the manipulation, and they shouldn't be paid separately because they were just really an adjunct to the CMT. And now DOBI found that that was improper and told Horizon to cease and desist. There were 2 other issues that weren't really important. I'm just going to address them very briefly here. Issue 3 was whether Horizon was essentially discriminating against chiropractors in violation of the statute that we have listed here. Now, DOBI found that there was no violation because this statute doesn't say insurance companies have to pay chiropractors at the same rates as other doctors. It just says that they can't discriminate, and DOBI found that there wasn't enough evidence to show there was actual discrimination, so they did in fact find that they had violated that Unfair Claims Settlement Act. The final issue was whether Horizon's in-network reimbursement rates, which were set at 80% of Medicare rates, was proper or not. Now, DOBI kind of gave a non-decision on this final issue and basically said that each each doctor could bring an individual claim on this issue, or if the parties wanted to come back before DOBI for additional fact-finding, they could do so. So that is really up in the air. But what we're talking about tonight is the bundling of E&Ms and modalities into that chiropractic manipulation reimbursement. Now, where do we stand now? Now, both sides, either the ANJC or Horizon, had 45 days from the decision on October 7th to appeal directly to the Appellate Division of the State Superior Court. That deadline fell on November 23rd, 2009, because the actual deadline fell on a Saturday, and it would then move forward to the first Monday, which is the 23rd. Now, Horizon didn't appeal. I mean, really, to the surprise of everybody, they did not appeal. It was confirmed with both the Appellate Division and Horizon's attorney. They did not appeal, although later on they tried to contact DOBI and ask for a stay of the decision, which DOBI has denied. Now, Horizon has now taken the position that the decision is only prospective in nature. So basically, it only applies to dates of service from 10/8/09 forward. They're still denying claims before that date, saying that the decision was not retrospective, it's only prospective. Okay, so, but the funny thing is that even in claims after 10/7/09, they're still denying them. So right now, there's actually, Horizon is going to be meeting with the Department of Bank Insurance, who's called them essentially up on the carpet in front of them to explain why they're not paying for these claims. Okay. One other thing is a lot of doctors have asked about what about the retrospective claims? What about the claims we submitted before 10/7/09? Now, the Association of New Jersey Chiropractors is presently looking into what either litigation or some type of action to try to get reimbursement for those retrospective claims, and I can't say much more about that at this time, but hopefully I'll have an update soon. Now, one big question that arises is, okay, what plans that Horizon manages or pays does this apply to? Now, our first two categories here is what this decision actually applies to. So any managed care policy, such as Horizon HMO, Horizon Point of Service, Horizon Direct Access, this decision directly applies to those plans. Same thing with the PPO and traditional plans. The Horizon PPOs, the traditionals, indemnity products, this decision is completely binding upon those plans. Now, Horizon has it's called the State Health Benefits Plan contract for the state, which are the state workers such as teachers, policemen, firemen, judges. The SHBP does not apply. I mean, this decision does not apply to it. There's a separate appeal process, and the Department of Bank Insurance actually doesn't have jurisdiction over the SHBP. So although Horizon administers this plan for state workers, this decision does not directly apply to it, and there's a separate appeal process if you're dissatisfied with what Horizon is doing in this respect. We're going to talk about that in a little bit. Now, finally, this does not apply to self-funded plans. Now, that also raises the question, okay, what is a self-funded plan? Big companies such as Microsoft and any AT&T, large employers, a lot of them actually don't buy insurance. They self-insure. They're the ones who are actually ultimately responsible for the claim. They may hire an insurance company such as Horizon to administer the claim, but Horizon doesn't actually pay the claim. So these self-funded plans are not governed by the Department of Bank and Insurance. They're governed by the United States Department of Labor. So they also have their own separate appeal process, and this decision isn't absolutely binding upon them.
Okay, thank you for joining us. Stay tuned where Jeff will go over the actual appeals process for those claims that have been denied by Blue Cross Blue Shield.